Wallenberg Center for Human Rights, which is one of the co-sponsors of this conference. And c'est un grand plaisir et privilège de présenter mon ancien professeur et mentor, Maître Karen Eltis. Professor Eltis is a tenured member of the University of Ottawa Faculty of Law in the Civil Law section and an affiliate of Princeton University's Center for Information Technology. Her talk today on hate speech in the digital era is as timely as it is important. Indeed, the digital age democratized the public sphere, providing new technologies that allow us to give expression to our highest values as a society. But increasingly, we see that these universal public values, the lifeblood of our democracy, and a collective source of inspiration that has underpinned every aspiration are being co-opted. We see a rise in racism, a rise in anti-Semitism, and anti-Muslim bigotry. These are all couched in the language of freedom of expression and other human rights rhetoric, and amplified by a networked environment where insightful truths are indistinguishable from hateful incitement. Professor Eltis is on the front lines of cutting-edge research at this important intersection, where the prevailing ideological trend is a laissez-faire attitude that online hate is a problem that will solve itself. Professor Eltis is an academic of integrity and innovation, one of the few to stand up and speak out on the need to rethink our approach. The importance of her groundbreaking work was recognized through the major research grants and prizes awarded to her by leading institutions such as the Law Commission of Ontario and the Internet Registration Authority. A testament to the wide resonance of her scholarship, the Supreme Court of Canada has used it as a basis for their decisions, directly incorporating her work into the text of one of its judgments. The intellectual depth and originality of her scholarship is an expression of her varied experiences as a leading scholar and practitioner, whether as a former director of the University of Ottawa's Human Rights Center, Harlan Fiske Stone Scholar at Columbia Law School, or as a senior advisor of the National Judicial Institute. Professor Eltis is a polyglot who speaks French, Hebrew, Romanian, Spanish, German, and Italian, but luckily today's presentation will be in English. We are delighted that Professor Eltis can join us here today to share her insights with us.
Thank you so very much, Brandon, for the kind words, truly humbling, and for this wonderful introduction, but most importantly, for your eloquent comments on a situation that is quite preoccupying and that I think needs to be addressed and addressed seriously. Bonjour tout le monde, c'est un grand privilège d'être parmi vous ce matin. J'aimerais remercier le Collège Vanier. J'aimerais remercier le professeur Erwin Cutler, qui est le président d'honneur. J'aimerais aussi remercier Naomi Kramer pour l'invitation d'être parmi vous ce matin. I'm truly grateful for the opportunity to speak to what undoubtedly is one of the most pressing themes commanding our attention. That is the theme of hate speech, incitement, and how it ties into the prevention of genocide with specific emphasis, as Brandon noted, on the digital age, and how the digital age brings changes, both quantitative but perhaps even qualitative, to our understanding of hate speech. Indeed, the symposium today comes at a time when historical, verified, and verifiable truth struggles to endure in the face of what you've heard recently as alternative facts, where fake news, even fake history, are insidiously and easily confounded with verifiable historical record. And this is done on the internet in particular. My comments today will emphasize the importance of preventively and proportionately limiting virulent forms of hate speech with an eye towards averting the sort of dehumanization that is known time and time and time again to pave the way to genocide. And a theme that you will see recurring throughout my comments is that of free speech, speech where the most vulnerable are not silenced. If free speech means silencing the most vulnerable groups in society and allowing louder voices, voices of incitement, to speak unhindered, does that truly comport with our substantive democratic values? Free speech as free speech alone, or free speech and equality, balanced proportionately, allowing all to live freely and in dignity in a democratic society? And when I say democratic society throughout my talk, I refer to the notion of substantive democracy rather than procedural democracy. I'll go into it further, but this is to say that democracy is no longer and should never be allowed to be interpreted as mere majority rule. Democracy is one that embraces and holds on tightly to values such as dignity, equality, and indeed freedom of speech as meaningfully interpreted. Going further, my remarks highlight the repercussions of the digital age for genocide preventions and the medium's distinct impact on the message. As you may have heard recently, going to the front pages, Google has laudably committed to curtailing hate speech and has even gone as far as to define hate content as, and now I'm citing one of the Google spokespeople, Mr. Schindler, I believe, so hate speech content is one that promotes or condones violence against individuals or groups based on race or ethnic origin, religion, disability, gender, age, the list goes on, or whose primary purpose is inciting hatred on the basis of these attributes. Now, in circles such as these, in human rights circles, this may sound redundant or familiar, but for a company such as Google, an American company that had for years embraced a vision of free speech that is a marketplace of idea vision, that is an absolutist vision, that is a first freedom vision, a vision quite distinct from our vision here in Canada, for a company, an American company, to come and say, hate speech is a problem for us too. We will define it and seek to limit it as it has, we can read in, become a problem, to me, is momentous. It is an important step forward. There remain issues, which I will address in the second part of my talk, that I think remain. So a lot of work remains for us to do. But since I've given a talk on a similar subject, I would say around 2011, this is a tremendous step forward, this very symbolic recognition, bridging an absolutist view with a view of speech that brings to bear or is cognizant of other values such as equality and the freedom of speech rights of the vulnerable. Prior to moving to this notion of the digital age, it is fitting to begin by an introduction. And I cite a passage that strikes me every year as the Jewish community gathers to read the Megillah, the scroll recounting, the historic scroll recounting the story of deliverance from annihilation or genocide, which is celebrated by Jews in the story of Purim. And the reason that I dwell on this passage is because it underscores the insidious roots that underlay and ominously precede most genocide attempts since time immemorial, right? Namely, racist incitement and scapegoating. So it reads, quote, "And Haman, the king's advisor, said to King Ahasuerus, 'There is a certain people scattered abroad, dispersed amongst the people in the provinces of your kingdom, and their laws are different from all people. If it please the king, let it be written that they may be destroyed.'" End of quotation. This is an ancient illustration of incitement, I may add, in the face of the king, what may be described as the king's apathy, another facet, that still rings true today, right? Over and over and over, whatever form it may take. Genocide, or attempts at genocide, as the Supreme Court of Canada itself recognized in the Keegstra case, are commonly preceded by agitation, incitement, and a variety of rhetorical techniques that include but are not limited to what a terrific scholar on anti-Semitism calls accusation in the mirror. So plainly put, what's really interesting about it is that through the hate speech, through the incitement, instigators of genocide or violence accuse the intended targets of the distasteful acts or worse initially, and ultimately it is precisely these atrocities that they wish to perpetrate against the vulnerable accused. So accusation in the mirror turn, if you want to say that a group is responsible for wars, that is a preface for ultimately leading a war against that very vulnerable group. So you turn them into the evil you wish to destroy. Right? So this is where we must be particularly suspicious and cautious whenever any group is vilified and accused of a sort of social ill, be it capitalism, communism, any ill, because that is ultimately how they become dehumanized, demonized, and easy targets for violence. As we have seen, as was mentioned by Dr. Small, propaganda outlets help explain how ordinary Rwandans, even children and grandparents, were influenced to participate in the killings in the Rwandan genocide. So a rhetorical technique used to dehumanizing its victims, imputing to them the worst human rights violators, so that if one considers themselves a self-respecting human rights activist, they need to weed out this evil from society. This is the terrible irony. A quick word on denial. That is very, very répandu, common on the internet. Genocidal affirmations of various incarnations are also preceded by the denial of previous atrocities against the vilified groups. So denial of historical victimization becomes a first rather than final stage in the genocidal process. And here I'm quoting Gregory Stanton, who explains genocide as a process rather than a culmination. And as Lidsky says, the denial threatens our collective memory and gains converts and therefore becomes an excuse for future persecution and future genocide. So that is the impact of denial, denial that is so easily confused for fact on the internet, which I will get to later. On the internet, where fact and fictions are practically indistinguishable, even by intelligent minds. We were holding, as I open a parenthèse, judicial training. And of course, who is more trained, who is more capable than our judges? And they found it in exercises very difficult to distinguish between scholarly authority, sources on the internet, for purposes of citation, and vitriol, unfortunately, that is couched in human rights rhetoric that emanates from anyone. Now, the internet is the great democratizer. It has allowed in the past only the moneyed, right? How much does it cost to get a page in the New York Times, a page in the Globe and Mail, and be able to truly express yourself? Do you express yourself if nobody is listening, right? The modern soapbox, where's the soapbox? It's online. So the internet is the great democratizer from that perspective. But it risks, for purposes of genocide and denial, which is our theme today, putting sur pied d'égalité, on equal footing, verified, scholarly, historical truth and vitriol, denial, couched in rhetoric, making it for an innocent mind, even an educated mind, not to mention a young mind who is looking online for information, who is curious, who wishes to learn, who is thirsty for knowledge. And here the knowledge comes at them almost indistinguishably. So that's where the component of denial is especially important. So to borrow Professor Cutler's important statement, what must we do? And whenever I find myself at odds, what must we do? From a normative perspective, the safeguard against democracy's procedural undermining by way of its own mechanism, as was the case in Germany, was addressed by constitutionally recognizing and enshrining rights such as equality and dignity, thereby presumably rendering void of legal force majoritarian decisions unjustifiably violative of these supreme values. When I start my charter class every year, I start it with two types of anecdotes. The first is I have an article on the board, and we have this old-fashioned blackboard that I copy from the old South African apartheid constitution. And it is the article of the apartheid constitution that guarantees equality, and then it has, and I don't have it reproduced here, it has, an unless unless subject to reasonable limits, something you would associate with any democratic country. And then I have an extract of it on the board, and I asked the students, what country do you think it comes from? And truly, it's well drafted, and it seems you have equality, but you have limits. And it takes them a while unless they've heard it from someone from the year prior. And finally, someone will say South Africa, and I'll say, which South Africa? Apartheid South Africa, right? Why is that important? Because a constitution is a tremendous safeguard. But these words, without proper judicial interpretation, without the interpretation, the substantive interpretation of an independent judiciary, right, not just one that serves the regime, is meaningless in practice. So this is where the culture of rights is crucial for the maintenance of these constitutional values that otherwise are beautiful words that we can cite to no avail. And the second point I make to them when I distinguish between procedural democracy and substantive democracy, it seems so technical. So we have procedural democracy, we have substantive democracy, we have the hierarchy of norms. I try to bring it back that Nazi Germany was a procedural democracy, one that had mechanisms, democratic mechanisms for elections and so on, that was subverted, right? That was undermined by Nazism. So in a way to say, was Nazism majority rule if you interpret democracy procedurally, then the answer that frightens us all is yes, right? So we cannot say democracy, oh, it's what the majority wants. That's why post-World War, so many post-war democracies, as Lauren Weinreb said, to use more simplistic language, chose to handcuff themselves, right, to limit their discretions and subject it to substantive values such as dignity as equality, principles that we, above all, have a duty to defend. So, as Andreas Kalivas said, in a democratic age where the idea of popular self-government enjoys a vast ideological hegemony, the effective challenge can only come from within. So he says, instead of directly attacking democracy, genocide deniers, proponents of violence will use a more deceptive and cunning strategy. So in the days of the Nazis, procedural democracy was harnessed, right, was hijacked and used. In today's age, it's a little more sophisticated. We have substantive democracy, so one has to subvert the language of human rights or disguise themselves as human rights activists. A very common example, a very famous, older example, before the digital age, is of Ernst Zundel, the Holocaust denier, who posed as a noble champion for freedom of expression, because otherwise it's not palatable, and appeared as CJC Congress attorney former President Mark Fryman says Zundel and his attorneys would appear in bulletproof vests, acting as victims of the enemies of free speech. Right? So you have to have this inversion of truths rendered more palatable online, where truths and lies are not easily distinguishable. And so taking back freedom of speech, just as the internet made it so that if one wishes to speak out against a powerful corporation, one is perhaps just as powerful. There's a story which, due to the offensive details I won't recount here, but one pizza empire was brought to its knees by a viral video that its minimum wage employees had posted online. The point is, suddenly, the internet gives power back to the powerlessness, right? So suddenly we recapture the freedom of speech. But freedom of speech substantively means freedom of speech not only for those who are the prominent voices, but for the vulnerable who are silenced by incitement. So with this in mind, democracies are duty-bound to take corrective action, not only to prevent the infringement of freedom of speech by inciters, but to protect victims' affirmative right to expression, dignity, equality, and ultimately, as these things go out of hand, and there was a discussion of what happened at Durban, also life and security, right? It is a variety of constitutional rights that stand with each other for what President Barack Obama might consider a vertical balancing, rather than one right and the state that attempts to suppress it. As Professor Shlomo Lapin wrote in the campus context, if one, and I'm quoting, if one group of students is permitted to engage in violent harassment of another without the decisive intervention of the university's administration, then the conditions of free and unfettered exchange of ideas are completely undermined, and the primary purpose, of university life is betrayed. End of quote. So, as I've said, the balancing should not be between the first freedom and another ill-defined interest, government encroaching and so on, but rather a question of rights versus rights and the proper balance to be achieved proportionally and contextually. In this context, and I will end with this part and proceed directly to the digital age, of now Dean Jean-François Gaudreau-Desbiens, who argued powerfully in the freedom of expression context, the dilemma, he says, of inhibiting speech becomes a duty to regulate against abusive forms of expressions because a constitutional democracy cannot tolerate radical denials of the humanity of some of its citizens. He continues, the danger of hijacking human rights narratives in the interest of racist incitement is not unprecedented. The lessons of France's Vichy regime, and here Richard Weisberg, Cardozo scholar, demonstrated how legal language, so as jurists we must be particularly aware, was associated, they used legal language associated with profound pre-existing social values in order to seamlessly subvert those very principles. So segueing now into the digital age, it's worth noting, and I think this will become, as jurists and perhaps as a society as a whole, our next challenge, constitutionalism, which I've referred to at the what must be do as a safeguard of democracy, was meant to restrain what? Government action, right? Governments. Most genocides in the past were spearheaded by, arguably, with the collusion of elites and so on, but by governments. While that surely remains relevant, much of the impugned incitement and denial of genocide occurs online, via social networking platforms, conveniently beyond the reach of constitutional protections. So this is the difficulty. Constitutional protections were our shield against democracy being subverted and undermined. But now, where the hate is found, if hate is the prelude to genocide, the hate is found somewhere that, to a large extent, is beyond the reach of constitutions, at least at first glance, at least traditionally speaking. Since this is not a law class, I won't speak to the exception of the Quebec Charter, but law must grapple with this. All the constitutional safeguards, or the principal constitutional safeguards, target the government and therefore require government action. Yet most hate speech that flows online is housed on social media platforms that are considered private, thereby arguably, at the very least, weakening the constitutional safeguards that stood between us and what we fear. As I said, the good news is that some platforms, at least Google recently, after a number of large advertisers threatened to pull ads, they're advertising soaps, and then you have Nazi messages popping up. You can imagine the dismay that caused. So the U.S. companies are reluctantly, but still, stepping into the role of international arbiters of free expression. Good news, they're realizing hate speech is a problem. Stepping in as international arbiters of free expression, stepping in themselves, stepping in with algorithms, that's what I'm going to speak a little bit about. Big question mark, right? So it's a combination, and I have here, I won't go through the whole thing, but they are deploying artificial intelligence to prevent hate speech. Now, can an algorithm sensitively balance free speech equality as a constitutional judge can? Is the transparency and accountability there? I leave the question to you. Tremendous problem if this is not subject to oversight. So I looked at, I'm a comparativist, and this is not a law lecture, but one piece de solution, as we call it, to what to do when these problems are private and the Constitution was designed for government, when today those who are limiting hate speech online are either outsourced workers or being paid minimum wage, so you can imagine that they've not been judicially trained, or algorithms who are doing this, which, by the way, an example that's very preoccupying, I don't know if you've seen in the Globe and Mail, there was a Vietnamese war child, a naked picture of a Vietnamese war child that was endemic, symbolic of the horrors of war. And some algorithm, I believe it was one of Facebook's outsourced workers who sort of, looked at it and said, naked child, must ban. And so they censored this quintessential picture of the horrors of war because the war child was naked. So yes, we want to limit hate speech in order to prevent dehumanization and genocide, but we want to do so in a manner that is transparent, accountable, and of course reasoned, right? We're not going to leave that up to algorithms or individuals who have very little guidance through no fault of their own for this type of work that most constitutional judges, in my experience, find very difficult. So one thought, one thought is, how are we going to limit hate speech online? We're already a step forward, but do so in a way that is accountable, that is transparent, and that has oversight. The internet, particularly information sharing via social networking, blogging, serves to radically compound the difficulties of hate speech. The ability to corrupt even the most educated minds by distorting information is amplified by the lack of editorial oversight online. It is indeed the medium's very structure that tends to bestow the appearance of legitimacy and veracity on even the most mendacious of sites. Therefore, if only due to the arduous tasks of distinguishing between reliable, authoritative cyber sources and those peddling racism and fabrication under the guise of respectability that the network environment tends to impart. For online truth is easily ingested and confounded with insidious lies in the marketplace of idea models. This even led First Amendment defender Anthony Lewis to suggest that, quote, in an age where words have inspired acts of mass murder and terrorism, says Anthony Lewis, it is not as easy for me as it once was to believe, and he said this a few years ago, that the only remedy for evil counsels is, in Justice Brandis' words, should be good ones. So this is especially true of the internet. Cloaking falsehoods in human rights rhetoric online, and who will supervise this? Who will editorialize it? Will it be corporate actors? Will it be foreign corporate actors? Will it be algorithms? Will there be no charter input into this? This is a new issue that confronts us, presumably all the more so. So an old issue that haunts us with a new twist that confronts us, as the internet is a true marketplace of ideas, but one where dangerous words, hateful words, genocidal words may have disproportionate impact. And so the rationale of even-handedness, ostensibly affording all speakers a platform and allowing the reader or listener to decide, though appealing at first glance, and it truly, truly is. But look, 20 years later, we're coming to the point where even the staunchest defenders of that approach had said, and maybe it took some advertisers, but he said, look, we can't, this approach is untenable. We must do something. The question is how this something will be done, because we don't want to get to a case, there was a case a few years ago where an anti-Muslim page was posted on Facebook. This was discussed at an Ottawa conference a few years ago. So there was an anti-Muslim page on Facebook. Muslims correctly complained to the company and asked for it to be taken down. You may have heard this one. So the company said, fine, we'll take it down. And so showed up a Jewish group and said, there's also an anti-Semitic page. Can you please take that down? So one would think the company would say, okay, well, let's get rid of racism. No, instead they reinstated the hateful page against the Muslims and left the anti-Semitic page against the Jews. So now we're all on this sort of false Sesame Street pied d'égalité where free speech prevails, and that's really a distortion. That's not the idea, nor censoring the war child or more recently an anecdote of banning cookbooks coming from Syria because the artificial intelligence that was supposed to look for inappropriate, quote, inappropriate words associated with the war and the genocide caught this innocent cookbook and censored it. Right, so that's not what needs to be done. There needs to be a revisiting and re-understanding of speech in the digital age, one anchored in transparency, in accountability, one that gives courts a role. A final thought on this point. It's opportune, it's an extremely opportune time to revisit and perhaps even adapt, and this can be done through interpretation, judicial court interpretations, our theoretical paradigms of expression in relation to other values in the digital age. Increasingly, many, and I've mentioned a few who were initially resistant, question the soundness for a laissez-faire approach, both normatively and descriptively. Given that in practice, much balancing and regulating does in fact occur. It just occurs on an ad hoc basis. Oh, this cookbook looks suspect, let's get rid of it. No, one needs a structured, conceptually sound approach. As Jack Balkin, a prolific scholar focusing on internet governance, argued, he says, digital speech argues our perspective on freedom of speech, and technical innovation alters the social conditions of speech. We too, he says, must change the focus of free speech theory in a manner that would encompass, I'm still quoting, a large concern for promoting democratic culture. So in the end, just as in my example, where the South African Constitution had it all, so to speak, but was lacking the most essential ingredient, which is that of democratic culture, which is that of standing up for rights, which is that of an independent judiciary standing up for substantive rights. So while some invoke the supposed futility of regulating online behavior, the symbolic value of collective condemnation of racist incitement by the law cannot be discounted. Legal historians observe that the law represents the moral hegemony, may be going too far, but in any event, but has a symbolic and instrumental social function, and law and history are intertwined. In this manner, law joins the forces that build historical narrative. Cases are not just decisions, but become part of the historical records. So as we grapple with regulating speech online, with regulating hate speech online, with an eye towards preventing dehumanization, demonization of vulnerable groups, we need to think about who's going to do this, and law needs to be part of the conversation. It can't just be artificial intelligence or algorithms or workers who are told what to do in a way that is unaccountable or is random. So whose responsibility? There cannot be power without responsibility, and if courts find it difficult to strike the proper balance between these constitutional rights, surely non-court actors presumably lack the judicial training. So oversight is crucial. As we struggle with fostering transparency in judicial appointments at home, let us be aware of the importance of maintaining Canadian courts' oversight of charter values rather than letting them become the province of the unknown through, for instance, a very narrow interpretation of state action. So, as was the case with the war trial, half a world away, someone is telling us this needs to be censored. No oversight, no accountability, no Canadian courts, and Canadians are impacted. So, my time has come to an end. I'll only say for those who are interested in comparative law, there is a very interesting Israeli precedent, Chevra Kadisha, a case where, under the pen of a judge, Justice Zamir, for when a private, an otherwise private body is fulfilling a public function, they may be, under certain circumstances, subject to constitutional imperatives, as would the government. So it's akin to government action because it's performing a public role. So if social network platforms begin either positively, if their will is good to limit hate speech, where is the oversight? So maybe the oversight can be taken where the function that is performed is of a public nature. But this is only some crumbs to hopefully get our communal reflection going. In the end, fundamental principles such as accountability, transparency, and most importantly, substantive human rights shaped by their respective communities and understood by them and interpreted by their independent judiciary cannot be reduced to the singularity of their absence in this borderless, networked world. Thank you very much. Questions?
Thank you to Professor Eltis for her, as always, inspired and inspiring remarks. At this point, we'll take any questions. And we'll also have the opportunity to discuss.
I wasn't planning on asking a question, but I think it would be really sad if there were no questions, and I hope other people in the audience will stand up and remember to ask questions. I think